Okay, a couple of announcements that I have. When I posted your unit last night, I had originally intended it for to be 1 week, but now I think I want it to be 2 weeks. So I'm going to lecture today and Thursday. Then next Tuesday, we'll have our guest speaker. And then next Thursday, we'll have our case discussion. So you will not have a quiz on this for 2 weeks. If that makes sense. I'll go back and revise what I posted to reflect all that. But I just want to make sure everybody hears me say that. This will be a 2-week unit. You have one quiz on it, but the quiz will not be due for 2 weeks. You'll have a couple of easy chances for hundreds from here on out. Both of the guest speakers, I'm going to give you an assignment on. It'll be like turn in 3 things that you learned or found interesting from the guest speakers speaking. And there'll probably be an Easter egg in there somewhere too. So as long as you can get that back to me, that'll be an easy 100 for the first guest speaker and second guest speaker. We'll have a quiz on this unit, and then that leaves us with 1 week at the right before Thanksgiving. And I'll just do class. I'll lecture one day, and we'll have guest speaker one day that week. So we're almost there. Remember to look. Last week we went over what's remaining in this class, and part of that handout that I posted to the unit last week tells you when the final exam dates are. I can't remember off the top of my head, but please make sure you're familiar with those because it's a take-home open note exam, and you can do it, I think, starting sometime Thanksgiving week all the way up through sometime in finals week. So you'll have a good 10-day window, I think, to do the final exam at your own convenience. So we're really almost there. Just this unit and one more unit, that's all the content we're going to have. I didn't get around to posting a discussion question for the previous unit, so I just scratched that out. You don't have to worry about a discussion question for Unit 9. Anybody have any questions before I jump in? Everybody knows where we are? All right, I can't believe we're almost to the end of the semester. I really like that we don't have class after Thanksgiving. Do y'all like that? This is like such a wasted week. I feel like sometimes coming back and do 1 week of class. Yes.
Sorry, I have one question. Maybe you can help me after class. It's
Sure.
about like the scheduling the appointment for the.
Okay, no, let's talk about that now. And anybody, the question is about scheduling your appointment for your interview.
Yeah.
Are you looking on Handshake right now?
Yeah.
Are you looking on the options of what you can schedule?
Yeah, that's what I'm like. Look, I don't know.
It's called interview prep, or it's not called mock interview. Y'all help me out. It's called. Say that, Sarai. Interview. Practice/prep, something like that, Austin. I think that's right. Do you see it, Drew?
I'm on the Career Center. Is that what I'm on through Handshake?
Yeah, let's do this now while we're at it, just in case. Does anybody not know how to schedule their interview? All right, y'all listen up. We're talking about it.
And then schedule them, and then just do the time. You got to request it, and then they'll send you where to go.
So, Austin, talk us through what you just told him.
You go to the Career Center thing, and then you go to Handshake, and then
You have to go to Handshake, and then there's a tab called Career Center.
All right, Handshake, Career Center,
Yep.
appointments.
And then you go to appointments, and then schedule a new
Schedule a new appointment.
And then, I guess, just
Under, and then you will choose
practice.
interview practice/preparation. There you go. If anybody needs a refresher on that, ask. Thank you for asking that.
And then also, this is for the, because you also have to schedule one to go over the.
Yeah, but you could do them together.
Oh, okay.
You can do your resume review and your interview prep together.
Oh.
That's fine. I think you just need to make sure that they're expecting you to do both when you go, because there's not an option to like choose both for one time. When you sign up, is there like a comment box?
Yeah.
So, all right, there is. So you can say, I am scheduling my mock interview / resume review for Professor Tebow's class. They're expecting y'all, and they know that you're coming. So, and they've seen a lot of you already. So I would just make sure they understand what it is that once they know it's for this class, they'll know what to do. Does that make sense? I'm not making a lot of sense this morning. Mayana, did that answer your question?
After handshake, I got lost a little bit.
All right, handshake. Handshake, go back up. Oh, are you in handshake?
No, I'm not.
All right, go in handshake. And then Career Center over there on the left. And then appointments. Schedule new appointment. Click on that undergraduate career. And then your second choice is interview prep.
Interview prep.
Go back one. This one.
Oh.
There you go.
Okay.
All right, you guys are making me nervous. You're cutting it awful close now. I want to make sure they have enough availability for you, but I think they do. So, who hasn't done their interview yet? Okay, all right. That's on y'all. I mean, look, as long as you get it done, that's all that matters. Okay, employment law. So today and Thursday, I'll lecture on that. The following Thursday, we'll talk about our cases. If you have an employment contract with your employer, then that contract spells out the terms of your employment, what your pay is, what your responsibilities are. And in that contract, it should also say what you can and can't be fired for. All right, that protects you from being fired for no good reason at all. That's if you have an employment contract. If you don't have an employment contract, you are considered to be an employee at will. The employment at will doctrine applies. And the employment at will doctrine says that you can be fired or not hired or not promoted, or that an employer can base any employment decisions for any reason they want to, so long as they're not illegal. All right, let me unpack that a second. Soraya, if you work for me, now let's flip it around. Let's say I work for you, and I come in one day, and I do not have an employment contract, so I'm an employment at will. And I come in one day, and you say to me, I am really tired of you. You have gotten on my last nerve for the last time. You're fired. Okay? That's legal. There's no law that says you can't fire me for not liking me. All right? Davis, if you fire me because you don't like the shoes I'm wearing, that's legal. He's looking at my shoes. It's totally legal. All right? This is for people, again, who don't have an employment contract. You have an employment contract, it's going to say things. Does anybody in here have a contract? Has anybody had one before? All right. Both of you guys did. So do you remember anything about like the reasons that it said why you could or couldn't be fired?
Mine talked about like a strike system.
Okay.
Like strike, so
all right.
Fire me before,
so it set up a progressive discipline system, right? So that like if you did one thing wrong, they couldn't fire you for it. They've got to discipline you and write it up, and it's progressive. Maria, anything you remember about yours?
Yeah, pretty much like the warnings you have to receive before getting fired.
Okay. All right. That's typical in an employment contract. Progressive discipline is pretty common to be found in things. Aiden.
I know for, not necessarily for the regular line crews, but for our specialized line crews, any safety violation can be immediate fire, like no ifs, ands, or buts.
Okay, so it established some things that maybe it was progressive discipline, but it had a category of things that were terminable offenses no matter what. That's pretty typical too. So if you have an employment contract, it is incumbent upon you to read it before you sign it. You know, I talked about how we click through a lot of things. That's not something I would click through. You need to know what the terms of your employment are. All right, but for those of us who don't have employment contracts, we are subject to employment at will, meaning we can be fired for any reason so long as there's no law against it. Now, we're going to spend a lot of time, the end of class today and Thursday, talking about the laws that do make it illegal to fire people for certain reasons. Religion, race, age, disability, things like that. Those are illegal. Okay? So just because you don't have an employment contract and you're employment at will, it doesn't mean that your employer can fire you for illegal reasons. But there just has to be a law prohibiting it. There's no law that says that I can't fire somebody because they get on my nerves, or I don't like the way that their voice sounds, or I don't like the perfume that they wear gives me a headache. Okay? That's all legal. And it's within our freedom to hire and fire as we like, so long as it's not illegal. So that's how employment at will works. Employment laws are a mixture of federal law and state law. And the way that works is that Congress will pass employment laws that apply to everyone in the country, and each state is free to supplement those laws with extra protection, but they cannot pass laws that take away from federal protection. So a great example of that is minimum wage. There's a federal law that establishes the minimum wage. Who knows what it is? $7.25. Hasn't changed since 2009. All right? Any state is free to pass a minimum wage law within their state that's higher than $7.25, but no one could go below that. I was Googling this morning just to see out of curiosity if every state has a minimum wage higher than $7.25. Almost all of them do. There were like 5 or 6 that didn't. There were like, I may have my numbers wrong. There were like 4 states, I think, that had a minimum wage that was the same as the federal minimum wage, $7.25. And there were 4 or 5 states that had no minimum wage. So therefore, the federal minimum wage controls. Georgia was one of them. Georgia does not have a state minimum wage. Some states like California, I think Washington, maybe New York have minimum wage laws that are well in excess of the federal level. I think California is $16 now, or New York is something like $16, something like that. Anybody have any personal experience with higher minimum wage laws in other states? I think California is maybe the highest. $16.50 is California, Austin? New York. Look up, Google Seattle. Because I think I want to say the city of Seattle also stuck in my mind that they have a high minimum wage. Maybe it's all of Washington State. Anyway, 16 is a lot higher than 7.25. I wondered why the federal government hasn't increased the federal minimum wage, but I think it's just because most states have already done it for them. But it's certainly inflation and the cost of living has increased over the last 16, 17 years to where we would think the minimum wage would be higher. On page 2 of your outline lists the names of some federal laws. I'm not necessarily asking you to know the names of those federal laws, but I do need you to know that there is federal regulation of minimum wage, of overtime laws, of things like that. But I'm not testing you on, like, I think your outline talks about the Davis-Bacon Act. We're not getting into that. I do want to get into overtime for a second. Here's how overtime works. Employees are classified as either exempt or non-exempt from overtime. Exempt means that no matter how many hours you work in a week, you're not making overtime. You're making your regular pay and that's it. If you're non-exempt, that means you get overtime. And any hour over 40 that you work in a week, you will make your hourly rate plus time and a half. Anybody in here get overtime? Garrett, overtime? You guys both get overtime? That's a lot of hours at Chick-fil-A during the week. that surprises me a little just because I feel like they have so many employees, but there is a need for overtime. Is that pretty standard, Austin, that you got employees making overtime? Is that because you have a shortage of employees, or it's just how it shakes out? Okay. So there's certain ones that you need. And if it's more than 40 hours, you're willing to pay it. Okay. Mayana.
Yeah, during starting like Thanksgiving week at Target, you get overtime all the way up until January.
Gotcha. And I had somebody in earlier classes like that too. Seasonal, rather than hire a bunch of new employees that they only need for a few weeks, they'll just use their existing workforce and work them more hours. If you're not familiar with overtime, let's say that you work 50 hours in a week and you make $10 an hour, you would get paid for those first 40 hours at $10, and then you would get paid for your overtime 10 hours at $15 an hour, time your regular time plus half. So that's how that works. Until recently, overtime was taxed. Now, under the bill that Congress passed fairly recently, overtime is no longer taxed. Has anybody gotten an overtime check since that was passed? When was the big, beautiful bill passed? The question is, I don't know when it goes into effect. Like, is it immediate, or is it January 1st, or is it whatever? Okay. So it may not be in effect yet, but it will be. So eventually, if you make overtime, you will not have to pay taxes on your overtime amount. You have to be careful as an employer and an employee about how you classify your workforce in terms of whether they're exempt or non-exempt from overtime. All right. The people who are exempt, who don't get overtime, are usually your salaried workers. They have managerial duties. They have duties that involve use of discretion and judgment. They're managing people. They're making, independent judgment on matters of significance, your outline says. You guys are non-exempt. You're hourly, right? Austin, are you? Hourly. All right. Anybody in here exempt from overtime? Anybody in a salaried job that they don't get overtime? All right. So military, that would be salaried, which is interesting because it's hard to fit that into the definition of of exempt. But anyway, so you need to be careful if you're an employee that you're being classified correctly. If you're salaried, but you think that your job is not managerial and doesn't involve the exercise of independent judgment, and you're working overtime hours, but you're not getting paid for them, you need to make sure you're classified correctly. If you're an employer and you have classified some of your people as exempt, but they're not really exempt under the definition of the law, then you're opening yourself up for a lawsuit for not paying people overtime when they should be getting it. So just because you get labeled exempt or non-exempt by your employer does not mean that that's how the law would label you. Most employers do it correctly. It's a big deal to them. I would say most of the bigger employers, because they have HR departments that are trained and paying attention to these things, but maybe some of your smaller ones would rather pay somebody a salary and not worry about tracking hours and overtime when they really should be. And so that could be an area that you might have some exposure if you've classified people wrong. Let's talk about family and medical leave for a second. So FMLA for short is a law that was passed in 1993 by Congress. And it says that if an employer has 50 or more employees, so it doesn't apply to people with less than 50 employees, 50 or more, you are required to give your employees up to 26 weeks of leave per year after they've been with you a year. So you got to be on your job a year before you're eligible for it. Once you're there a year, you can take up to 26 weeks, that's half a year, off, as long as you have a reason that qualifies under the law. What are those reasons? To care for new children, to care for an adopted or a foster child within 1 year of that child being placed, to care for a seriously ill spouse, child, or parent, to care for themselves if a serious health condition prevents performing essential job functions. I'm going to come back to that. And then the last one is to deal with any non-medical emergency that arises out of the fact that a family member is on active duty in the military. Okay? Let's say that Maria is my daughter. She gets deployed. She has young children, and she needs me to take care of them for the first 4 to 5 weeks or so till we can figure something out. I could go to my employer and ask for family and medical leave, and they would have to let me have it. Okay? The way it works is if you want to get family medical leave, you go to your employer and you apply for it. They check your reasons. If they agree that your reason is covered by the law, they'll have to give it to you. If they disagree that your reason is covered by the law, or they think you're not entitled to it, then they could deny it. If they deny it, then the employee would have to take them to court to sort that out. So I want to go back to the where I think we see a lot of litigation. To care for themselves if a serious health condition prevents performing essential job functions. All right, that's what the law says. The law doesn't spell out what a serious health condition is. We could argue about that between employer and employee. I could come into Dean Kidder's office and say, I need 12 weeks off starting tomorrow because I've got a cold. All right? Dean Kidder could say, that is not a serious health condition. I'm denying your leave. You've got to come and teach for the rest of the semester. If I disagree with that, I can sue her about it or sue the school about it. And the judge or the jury would decide whether or not my cold qualified as a serious health condition. Lawyers from both sides would look at previous cases. Remember how we talked about precedent? We would look at previous cases where maybe somebody presented a cold as a serious health condition. And if the courts said, no, that's not, that would be good case law for the university to use against me. If I found cases where courts said, yeah, a cold is a serious health condition, then that'd be good for me to use. But it's a case-by-case basis, depending on what that particular employee needs leave for. And then we would measure that against what precedent says and against the facts and circumstances that are unique to that individual, and the court would make a decision on whether or not that qualifies. All right. We could also argue about whether or not the serious health condition prevents performing essential job functions. I could say I have the flu and I want medical leave. And Dean Kidder could say that doesn't prevent you from performing your essential job function. You can sit at home and record a lecture and post it online. You don't have to be present for that. So we could argue about that as well. Maya.
Does bereavement come into this, comes into play?
Bereavement, I think, bereavement does not, I'm not reading bereavement into the definition of family medical leave. I think for bereavement, you can take your personal leave days, but I don't think you could say hey, I need to be out 12 months. Now, bereavement could turn into a serious health condition, like maybe I become clinically depressed and my doctor then says he is suffering from depression or some sort of trauma or anxiety as a relation to the death. But the death itself doesn't give me the right to just take time off. Does that make sense? I would just have to use personal leave time for that. Most everybody has a certain number of days you can use for whatever you want. That's not part of family and medical leave. This is saying I need to be gone for an extended period of time. All right, a couple of other things to know about family and medical leave. It's not paid. So if I take up to 26 weeks off of my job teaching here to care for my wife who's ill, or because we adopted a child, or I had a qualifying reason, they have to let me take the time off, but they do not have to pay me. That tends to squash a little bit of people just taking medical leave for no reason. Your discussion question for this week, which I promise I will put up this week, is a very short New York Times article talking about what countries around the world do for medical leave. And you may be surprised to learn that the United States is an outlier in that we allow less medical leave than other countries, and we don't pay for it, and most other countries do. So your discussion question is something along the lines of, what do you think is the proper balance between time off and how much the employer should be able to pay? All right, if we're talking about Target, and you need to be off for 12 weeks because you break your leg, I don't have much heartburn about saying Target ought to be paying you for some of that. Okay? I don't know about all of it. We could debate that. But if I, as a small business owner, I've got only 50 employees, let's say, and you are my CFO, and you're the only person that can do that job, and you want to be out for 26 weeks, and now if the law says I have to pay you for that, and I've got to hire somebody else for that other half a year that you're gone to do that job because I can't cover it with other people, that strikes me as a little burden. I mean, it's more burdensome than it is for a big corporation, if that makes sense. So it's sort of a sliding scale on that. It's easy for us to be able to see that big employers have the money and the ability to do that, where smaller employers don't. I'm also very cynical, and I think that if we mandated 26 weeks, let's say 12, whatever, however many weeks of paid medical leave, the cynic in me thinks that 75% of the workforce is going to figure out a way to have a serious health condition that prevents them from performing essential job functions for however long they get paid for. Automatically. As in, and I'm not saying I'm exempt from this, but let's say, oh, you mean I can take up to 12 weeks off and get paid? Why wouldn't I do that? That sounds like a great idea. Get paid for not working. So I think there's some trade-off, and I don't know the answer to this. I'm sure it's been studied, but I'd love to know sort of what a sociologist or somebody who's done the research, what that shows about countries that do have paid medical leave. Do they have higher rates of employees taking leave than we do? I bet they do, but I don't know. Employers are free to offer paid leave if they want to. They're just not required by law to. So does anybody have a job that has paid maternity leave or paternity leave? Lots of companies do that. And offering benefits like paid leave for those things is a way that companies can compete in the marketplace for talent. Hey, come work for us. Even though we don't have to pay you when you have a baby, we will. We'll give you 6 weeks of paid maternity leave. And that's a way that they can differentiate themselves in the marketplace. But the general rule is the employee is entitled to the leave, but they are not entitled to be paid for it. All right, once the employee comes back from leave, then what happens? The Family and Medical Leave Act says that they are entitled to be restored to the same position or a substantially similar position. You're not guaranteed your exact job when you return. you are guaranteed a similar job. Now, we could have some litigation about that, couldn't we? All right. Let's say that I go on leave, and when I come back, they're like, well, we had to hire somebody else to teach all your classes for the rest of the semester and the first half of next semester. We're going to keep them in place. We'll just make you a substitute teacher, and you can be paid by the day, $150 a day. I would be successful, I think, in arguing that that is not a substantially similar job. The duties aren't the same. The pay sure isn't the same. The work schedule's not the same. Let's say that I work first shift at a factory. I take medical leave. I come back, and now all of a sudden they put me on third shift. Same job, same pay, but different hours. Is that substantially similar? I'd argue that it's not if I don't want to be on third shift. My employer would argue it is, right? I mean, Autumn's nodding. There's a good argument to be made it is. There's a good argument to be made that it's not. What if when I come back, they put me in a similar job, but they're paying me this new job, which is similar, pays $10,000 less? Is that substantially similar? It depends. Who can make the argument that it is substantially similar?
I mean, if you're making $1 million a year before.
That's right, Seth. I make $1 million a year. When I come back, they've given me a similar job that pays $990,000 a year. Substantially similar? Statistically, yes. If I make $50,000 a year and I come back and they want to pay me $10,000 less, then I've got a problem with that. That's a 20% pay cut. That is, I'm going to argue that's not substantially similar. So it's not just the job duties, but it could be the working environment, the working hours, the pay, all those type of things. Any questions on family and medical leave? All right, flipping the page to the Occupational Safety and Health Act. This was a law that was passed in 1970, and it guarantees minimum workplace standards for safety. It's administered and enforced by the Occupational Safety and Health Administration, which we know as OSHA. And from our discussion about administrative law, you will remember that OSHA is a federal, and they have state agencies too, an agency of the executive branch of the government whose task is to carry out and enforce OSHA regulations. They make law through rulemaking, administrative law, and those rules apply to workplace safety. We talked about this some at the very beginning of this semester. Since we had that discussion, have any of you been more aware on the job of OSHA things, or have you come up against an OSHA requirement and you're like, oh yeah, that's what Professor Tebow was talking about? You guys at Chick-fil-A have OSHA? I mean, I know you have OSHA, but does it come up at all in your daily jobs? Kinda?
Yeah, I guess there's a bunch of health stuff that really reported.
Right. I'm recording this now, so.
It's just like small things.
Yeah,
Like
but
a little burn or something like that.
like temperatures and, this is what we talk about, having ladders that have certain load-bearing capacities and the rungs are certain distance apart and things like that, and wearing hard hats and all these safety regulations. You've probably seen in your break room some posters about it. I think they're required to be put on the wall. But we're not really getting into OSHA in this unit any more than just knowing that it is a federal law that regulates workplace safety, that its purpose is to provide safe workplaces, and that it's administered by OSHA. That's really all I want you to know about the Occupational Safety and Health Act. Workers' compensation laws. So workers' compensation is set up on a state level. So each state has their own workers' compensation system. And what that does is that if you're injured on the job through no fault of your own, you can apply to the state to be reimbursed for your medical bills and your injuries and things like that. And the state will pay you. You don't have to sue your employer for it. The trade-off is that if you do make a claim through workers' comp, you cannot sue your employer. All right, so it works for employers kind of like insurance. Every employer gets taxed to pay into the workers' comp fund. Okay, and then whether or not their employees have to use it or not, they just pay the money in. The state pays the benefits back to the injured worker. It could be more, it could cost more than what the employer is paid in. The employer pays a flat rate based on number of employees, based on safety ratings, based on like if your workforce traditionally files 500 workers' comp claims a year, that employer's tax rate is going to be higher than an employer whose workforce doesn't need the money. It's really insurance for employers. The state runs it. You get hurt on the job, you make a workers' comp claim, you get paid back from the state, but you can't sue your employer anymore. Does anybody have any experience with workers' comp? Yes, ma'am. You don't have to tell us about it, but
I was working at a restaurant here in Columbus, and one of my coworkers left the water running, and it went downstairs, and it was super wet. Slipped and fell down the flight of stairs while working.
you did.
Yes.
And so did your employer say, hey, you can file workers' comp, or did you have to figure that out on your own?
They told me to file it.
Oh, they wanted you to.
Yes.
Did they tell you that by filing it, you would be giving up your right to sue them?
No.
Would that have been an important thing to know?
Yes, because I'm having trouble with it now.
So that's a good point. I mean, if it was just like, hey, I had a medical bill, I just needed it paid, I'm fine, workers' comp would be great. But if you've got an ongoing thing that maybe outlasts what you got from workers' comp or have lingering issues, maybe you would rather have had the right to sue. Right. So it's a sort of they can't force you to do it, but they were probably like, if they were smart, well, if they were tricky, they would have been like, hey, you need to file workers' comp. Because then they know they're going to be protected. And they know the state's going to pay for it out of the common fund. That's the same way that unemployment works. That's a state program too. Works just like workers' comp. If you lose your job through no fault of your own, then you can go and make a claim for unemployment, and the state will pay you from the fund that they've collected taxes from every employer pays into. And that pays out a certain number of weeks. I can't remember how many weeks it is. 4 or 6. It got extended during COVID and then maybe cut back. But the idea is that the state will make up your income while you find another job. That's how unemployment compensation works. I remember a quick personal story. I only have one employee. I've never had more than one employee. And I had to fire an assistant one time because this person was just like keeping up with the Kardashians all day and watching Netflix and stuff, just not doing any job. And I'd never fired anybody before. So I kind of tried to let her down easy. And she turned around and filed unemployment. And I was like, well, that's bogus because I fired you because you were watching TV on the job. I shouldn't have to. I mean, it wasn't coming out of my pocket, right? I paid the tax into the fund. The state was going to pay it. But I just opposed it on principle. And I filed an appeal. We had a little telephone hearing. And they were like, well, did you give her warning? And I was like, no. Why should I have to warn somebody not to watch TV on the job? And they were like, when you fired her, did you tell her it was for watching TV on the job? And I was kind of like, well, I mean, kind of. And I lost that appeal. So the lesson I learned was when you fire somebody, you better make sure you spell out, no matter how much it hurts, all the reasons, or else they're going to be eligible for unemployment. But what really chapped me was the next year I got a notice from the State Department of Labor saying that my unemployment tax rate had gone up. They were going to make me pay more in because my employees had used it. I guess they're looking at me like someone who fires employees, and the people who fire employees who need it ought to be paying more than the people who don't. That's fair. But I didn't like that at all, that I had to pay more because I fired somebody and then I did a poor job of firing them, trying to be nice. But anyway, I'll get back on track. Income security. When you get your paycheck, I don't know if how many of you had the same experience, but I know when I got my first paycheck, I was in college and I was working at the YMCA in Athens, and I was getting paid like $6 an hour or something like that. And I calculated in my head, I worked 40 hours times 6 or whatever I mean. And I was like, that's going to be my paycheck. I got that paycheck, and it was nowhere near the math I had done in my head. Nobody had prepared me for what I was going to be taken out of it. I saw initials that I didn't even know what they stood for, right? So we've all had that experience. You look at your paycheck and you're like, hold on a second. They're taking out your Social Security. They're taking out Medicare. They're taking out all these government entitlement programs that later on in life you could be entitled to get paid back for. But those are federal laws as well that mandate what an employer has to take out of your paycheck. COBRA. You do not need to know what COBRA stands for. It's a long name of a federal law. But I do want you to know that COBRA guarantees workers who lose their job the right to keep their insurance, their medical insurance, through their employer for a period of time, so that they don't get fired one day or quit one day and then the next day all of a sudden they're uninsured. It gives them a grace period of time to get new insurance, either through their new employer or just going out and buying it independently in the marketplace. COBRA is generally not a great deal because the employee has to pay all of it themselves. I can still access the University System of Georgia insurance through COBRA if I get fired today, but I got to pay for every penny of it. The CSU no longer has to pay for it. It just guarantees me the right to have access to it if I want to buy it. It's usually a lot cheaper just to go out and get your own insurance, although the whole thing with the Affordable Care Act, Obamacare, and insurance and all that now is completely up in the air. They're talking about possibly messing with that to reopen the federal government, all this stuff. That's way over my head and certainly beyond the scope of anything that I would expect y'all to be responsible for on a quiz. All right, any questions about any of that so far? All right, the next part of the lecture for today and most of Thursday is now going to be about employment discrimination. Now we're getting into the area where there are federal laws that say what you cannot be fired for. There are laws that create protected classes of people from being discriminated against in employment decisions. Mostly, I will never ask you to know the names of laws, but I do want you to know Title VII of the Civil Rights Act of 1964. It's in your outline. It's a big heading in there. Title VII for short. That is the main federal anti-discrimination law. It's the main law that lays out all of the reasons that it would be illegal to fire someone or not hire someone for. What are protected classes? Everybody in here, believe it or not, is a member of a protected class. We might be members of we are members of multiple protected classes. We're not going to be members of the same protected classes. Okay, Aaron and I are not going to be a member of the same protected class in that I'm over 40, which is protected by the Age Discrimination Employment Act, and she's not. So she could be fired or not hired based on age, whereas I couldn't. I'm protected that way. Aaron's employer could not hire her on the basis of her being a biological female who, in theory, could get pregnant and give birth one day. I'm not a member of that class because that's biologically impossible. But if her employer said, I'm not going to hire you because even though, you may not ever have kids, but you might, and that's going to require you to take maternity leave, and then you're going to be gone, and I'd rather just not deal with that. Okay, that's illegal. That's on the basis of her gender. So that is a protected class. I'm kind of going all around it, but I want to give an overview first. I want to just talk generally about the protected classes. Age, anybody over 40. If I don't get hired and I think it's because of my age, I could sue for that. I've got to prove that it was because I'm old or that I was regarded as old. I've still got to prove that, but I could sue for it. Gender. If we don't hire somebody because they're male or because they're female or because their sex or gender is subject to childbirth, that's discrimination. So gender, sex is a protected class. Sexual orientation is a protected class. It wasn't up until about 5 years ago or 7 years ago when the Supreme Court decided that Title VII used to not cover sexual orientation, but they read it now to where it does. I've assigned you this case for next week. It's Bostock versus Clayton County. We're going to talk about it next week, and we're going to see how the court rationalizes reading a law that was written in 1964 that up until 8 years ago, they read as not including sexual orientation as a protected class. The law didn't change at all. The language is exactly the same as it was in 1964, but the Supreme Court 8 years ago said, we've been reading that wrong. We now read the language of that statute to include sexual orientation as a protected class. So that is a protected class now. Disability is a protected class. Religion is a protected class. National origin is a protected class. Color of skin is a protected class. Race is a protected class. Not only are you protected if you are scientifically a member of that race or that national origin. What I mean by that is if I'm Egyptian, my DNA can show I'm Egyptian, or I can trace my ancestry back to ancestors who are Egyptian citizens. I can prove that I have some Egyptian ancestry. I could prove that I have American Indian blood by DNA or some way, some scientific way. All right, that makes me part of the protected class. But I'm also part of that protected class if you think that I have those characteristics, even if I don't. So let's say that I am, my skin is of a tone that you can't tell about my race or my color. But I'm not hired because I'm perceived as being a minority, or I'm perceived as being white. But, well, let me make it clear. Let's say that I am not hired because I'm perceived as being a minority. But DNA, biologically, I'm not. Does that mean am I protected from being fired from somebody thinking that I'm a minority? Yeah, I am. That is, so employers cannot make employment decisions for discriminatory reasons that they perceive, even if they're wrong. So race, color, national origin, religion, disability, age, sex, gender. What else if I left out any of them? I'll give you another example of regarded as. Let's say that I am doing the hiring for a company and someone comes in dressed in, has a headpiece on. And I don't really know what religion that headpiece might be associated with, but I say I regard that person as, I think that looks Muslim, and I'm not going to hire somebody because of that. It doesn't matter if that person is Catholic or an agnostic or has no religion or doesn't care anything about religion. They're just wearing it for they think it looks good, or it's a Halloween costume or something like that. As long as I regarded them as being part of the protected class, they're protected by that from me making those assumptions. A couple things to say, and then I want to quit and pick up next week. The way that an employment discrimination case works is that the employee sues the employer and says, you fired me, you didn't hire me, you didn't promote me, you treated me differently, I didn't get the same hours as my coworker, I didn't get the same break, I don't get the same leave. I'm being treated differently in some aspect of my employment. We tend to think of discrimination as like I didn't hire somebody because of X, or somebody got fired because of X, but it could also be not promoted or just treated differently in the terms of employment. If that happens, and I think it was based on a discriminatory, illegal reason, I would sue my employer and say, you fired me because I am Baptist. Okay? And that's religious discrimination, and that's protected by Title VII. When I go to court, I have to say what happened and what the reason was that I think was discriminatory. Then the employer has to give what their reason is, their non-discriminatory reason. If they don't have a non-discriminatory reason, we're not going to make it very far to court. That case is going to get settled. Right? If they're like, yeah, you got us. We fired you because you're Catholic. That case is going to get settled. But if they're like, you know what, Tebow, you think you got fired because you were Catholic, or you think you got fired because you were old, you actually got fired because your students gave you the lowest scores on your review that any professor has ever gotten in the history of the business school. Okay? You got turned in for using inappropriate language or something like that. They're allowed to say what their reason was. Okay? Then it's up to me to convince the jury or the judge that what they're saying was not real and that the real reason was discrimination. We live in a society where a lot of folks have a victim mentality. If I get fired, it sure wasn't my fault. There was a lot of people's fault, but it wasn't mine. First thing I want to do is talk about suing for it. Okay? We also live in a society where people still discriminate all the time. We don't live in a blind society when it comes to protected classes. Unfortunately, we just don't. And I'm not condoning that. I'm stating some facts. So there are plenty of cases where employment decisions are being made based on discriminatory reasons. There are plenty of cases where employment decisions are being made for no discriminatory reason whatsoever, other than that somebody did a poor job or broke the rules or were incompetent or some other legitimate reason. But it's pretty common these days for folks to feel like they've been wronged and to try to sue for that. So what happens is employee sues, says, this happened to me and it was because of this reason. And that's illegal. The employer says, nope, that did happen to him, but it was actually for this reason, and that's a legal reason. Then it's going to be up to the judge or the jury to look at all the evidence and decide whether or not the employer made that decision based on a discriminatory reason or not. All right. What does that look like? We talked about discovery in this class. In an employment discrimination suit, I applied for a job as a professor at CSU, and I didn't get hired. And I think it's because of my age. What all am I going to want to get from the school in discovery?
Average age of professors.
Yeah, I want to know what average age of professors are. Good.
The age of the professor hired, the age of the undergraduate.
Boom, Seth. That's right. Tell me who else applied, who got hired. If it was a 68-year-old woman, then my case looks terrible, right? If they hired some 23-year-old person who just graduated college, my case looks a little better. But yeah, I want to know what the other applicant pool was. The employer is going to be offering all kinds of evidence like, well, here's the interview scores of all the people. Tebow scored the lowest of every one of them. Here's the resumes of the other people. He was the least qualified of all of them, or at least he was less qualified than the person we picked, right? So that lawsuit is going to be all about what evidence we can gather and then what we can convince the judge or the jury actually happened. This is important for you to remember when you are documenting things in your job. Okay, we talked about this at the beginning of the semester. You don't have a crystal ball. There's no way to know what you might be sued for, who's suing you, and what they're going to allege. But there is a way for you to be very careful and meticulous to always document exactly what you did and why. And to make sure that that documentation is legitimate. Like you don't want to write down or send an email being like, hey, we're down to these three last finalists for this job. Definitely don't hire the man. Okay, whatever we do, let's not hire the man. That is something that's going to hurt you in discovery later on. So you don't ever need to write things or document things trying to game it. You just need to write it and document it, how it happened, what the truth is, and the legitimate reasons. And then whatever happens down the road that just has to fall where it may. So in my example of me firing my assistant and trying to take it easy on him, let's say that I tell Maria that I'm HR and I'm calling her and telling her she didn't get the job. I don't want to be mean and be a jerk about it and be like, hey, you failed this, you failed this, you failed this. But I also don't want to be like, hey, we're really sorry, but we just can't hire you this time. It just didn't work out. Hopefully you can apply again. I'm getting my employer in trouble. The reason that's going to be is because if she sues and says I didn't hire her because she was female, and I say, well, no, actually, it's because she scored the lowest on her test. You know what her lawyer's going to say in court when I'm on the witness stand? That's not what you told her. If that was the reason she didn't get the job, why didn't you tell her that? Why did you tell her she was a great candidate and you were so sorry she just came so close and she just wasn't quite the one? Okay? That makes me look like a liar. If I get to court and I'm saying on the witness stand, well, Mr. Attorney, the reason we didn't hire her was because she had the lowest score. Well, Mr. Tebow, where is that? Do you have the scores of the people? No, we threw that away. Oh, really? So you're just saying she made the lowest score, but you have no way of showing that. That's correct. So you have to be careful about what you say and what you document, because you could get asked about it later. Thursday, we're going to finish this lecture. You have no reading to do for now on Thursday. Your quiz is not going to be for 2 weeks. We have a guest speaker next Tuesday. I need everybody to be here. Oh, let's talk about that. The guest speaker next Tuesday is going to be at my 9:30 class. So you're excused if you have a conflict, like if you have another class or something. If you can come, I would encourage you to, just because I'd like to have as many people as I can when somebody's given their time to come speak. But if you can't make it, it'll be recorded, and you'll just have to watch the video of it. So next Tuesday's class is at 9:30. The second guest speaker we have in a couple weeks is going to be at our class time. So I'm doing one for them and one for y'all. All right, see y'all Thursday. If you came in late, let me know. And then Miss Davis, I want to make sure you and I get square. Miss Harris,
So we know 11 o'clock SL.
just on Tuesday. There is on Thursday. Yep. All right, let's see. Keyshawn, I got you.
I got a quick question for you.
Yep.
Right. So you was talking earlier, right? You were saying,
I got
some
you,
of
Miss
the
Hill.
jobs, sometimes. So I had a question. Like, let's say if a job, right, they don't schedule you again.
Mm-hmm. They don't schedule you.
Period.
Okay.
You have a job, like they don't schedule you. Period. 'Cause I had.
So you had a job and then they quit scheduling you?
I had a friend. He
Okay.
was telling me about a situation, and I thought I should bring it up because, like, he was saying that they stopped scheduling him during that time period, so he couldn't go to work, and he couldn't, like, it wasn't like he was fired.
Did he have an employment contract?
No.
All right. So why does he think they quit scheduling him?
He said he was like that he was working for a time period, and they stopped scheduling.
So it could be just because they just didn't want him to work anymore. That's legal. If they quit scheduling him because he's a member of a protected class or their real reason was discrimination, that'd be illegal. But he'd have to be able to prove that in court, which would be hard to do.
It would be hard to do.
Unless there's a smoking gun, unless somebody sent an email and it's like, don't give any more hours to so-and-so because he's something. If it says because he's a bad worker, that's not discriminatory. But if it said because he's black, because he's white, because he's female, because he's male, or whatever, that's illegal. Mm-hmm.
Okay.
Yeah.
I appreciate it.
Yep. Sure thing.
Yeah, it's another hypothetical question.
Yep. Go for it.
So let's say you were interviewing for like COO at Chick-fil-A.
Okay.
And you had 2 qualified candidates.
Yep.
One was a Christian.
Okay.
And then one was a Muslim.
Yep.
What the company culture, like they're a Christian-based company, you could say
So
you will align
we
better with
are
our culture,
talking about that next week.
but it's because
There is something called a bona fide occupational qualification. Like if I'm Pacelli and I need to hire nuns to teach, I mean they don't have nuns.
Yeah.
You know what I'm saying? It's okay for some people to discriminate on hiring if they have a good reason.
Yeah.
That would not be one of them.
Really?
Yeah, that would not be one of them.
Because that would be like a fair argument.
Yes.
It is our company culture.
Yes. Why would
Exactly.
we hire a Muslim when our whole company culture
We're
is
all
Christian?
about Christianity, we don't
But
accept
they
it.
are not hiring them because they're Muslim. I mean, it's not a I don't think it would qualify as a bona fide qualification that the only person that could run Chick-fil-A is Christian.
Yeah, that's fair.
But that's a great question. I'm glad you brought that up. We'll talk about that next week.
Thank you.
Which quiz do you need?
The one was yesterday, I think Unit 9.
Okay. Can you email me?
Yes.
All right. If you'll do that, I will email you that I've reopened it and that I did it to confirm it.
Thank
When
you.
you tell me, then I'll walk out and forget. So if you email me, I will do it. And I know you already did, but just email me again.
Okay, no problem.
Thank you, Jada. Yes, ma'am.
That's the thing. So I'm like coming in Thursday.
Okay.
I have military training.
Okay.
Just wanted to let you
You're
know.
excused.
And then the other thing is for the proof of the resume check and the mock interview. So I only received like an email from them, like stating when are my appointments.
Okay.
I already went to my resume check
Okay.
yesterday, and I have my interview next Monday.
If you can just get them to email you saying you came,
Okay.
just saying we saw Maria on whatever date.
Okay, I'll make sure.
I know it seems a little bit unhelpful that I haven't given y'all exactly how to do it, but I wanted to give everybody the freedom to just do it how they wanted
Yeah.
because I couldn't count on the Career Center to do it a certain way.
Yeah.
So I'm
They
just
don't
like,
send
whatever
me-
y'all
'cause
wanna
I
do.
was there yesterday and they didn't send me.
I mean, if you took a selfie of you and however you want to do it, it's fine.
Okay. And then the last question, why it's all in the final exam? Like, is it going to be terms? Is it going to be...
I'm going to talk a little bit more about that, but I'm going to give you a study
Okay.
guide, a
Okay,
pretty
good.
good idea of exactly what's
All
on
right,
it.
good. Because I was like, oh, I don't know.
It's very open-ended. It's more like things you telling me things you've learned or things that are, it's kind of, you'll see. I'm going to give y'all examples. I'm going to give you a really good
Okay.
guidance on
Okay.
it. So I'm glad you asked.
Will the exam be open though?
Yep, sure is.
Also, I know the exam's due on the 6th. You said it's going to be open earlier.
I think I'm opening it. If you look in that remaining schedule that I posted last unit, it says the date that it'll go live.
Because I'll be out the 4th to the 7th.
Yeah, I like to give y'all a wide window to do it when you want.
Yeah, because I'm having to go and like reschedule all of my.
Yeah, I just feel like it's not fair that some people have exams like clustered together and then some get them spread out. I just figure you do it when you want.
Yeah.
Will you email me everything that you need me to reopen? And I will do it. but I need people to, I need it in writing because I'll forget. So what I do when I get those is I save them and then I do them and then I respond back, this is done. So you just tell me how long, which ones, and I'll give you till the end of the semester. If we run into problems with that, let me know because we always have the option of doing an incomplete. That gives you a year. So I'm going to leave that up to you, but I'm totally willing to work with you on it. Okay, does that make sense? Any questions for me on it?
Will you put the videos with the chapter we were doing? Is that